Hello everyone, I'm Debojit Das and welcome to Courts Today by LiveLaw, where we bring you the most important updates and intriguing developments straight from India's courts. So let's see what's making headlines today. To get things started, we look at the Supreme Court, which has expressed its exasperation regarding the arrest of two police officers accused in the custodial death of one Deva Pardhi. The 26-year-old Deva Pardhi was arrested in a theft case along with his uncle Gangaram Pardhi, who remains in custody. His mother alleged that Deva was tortured and killed by the police, while the Madhya Pradesh police insisted he died of a heart attack. Back in May this year, the Supreme Court had already transferred the investigation from the MP police to the CBI after finding that the local police were attempting to cover up and influence the case. But months later, the accused officers Sanjeet Singh Mawai and Uttam Singh Kushwaha still hadn't been arrested. A visibly upset bench of Justices B.V. Nagarathna and R. Mahadevan pulled up the CBI, remarking, "You are pleading helplessness. That feels like protection." The judges also issued a stark warning. If anything happens to Gangaram, that is the only eyewitness, the agency will be held accountable. There cannot be a second custodial death, the court said. The court has ordered the officers responsible for the investigation to file affidavits by Thursday, and the matter has been listed on September 25th. With this order, the pressure is now squarely on CBI to act and to ensure accountability in a case that has come to symbolize the fight against custodial abuse. Next, in a politically sensitive case, the Supreme Court has raised pointed questions in the plea by Balwant Singh Rajoana seeking commutation of his death sentence. Justices Vikram Nath, Sandeep Mehta and N.V. Anjaria asked the centre bluntly, "Why did you not hang him till now? Who is to be blamed for that?" suggesting that the delay itself could be culpable. Rajwana was convicted in 2007 by a special CBI court for his role in the 1995 assassination of the then Punjab Chief Minister Balwant Singh, under charges including conspiracy, murder, and involvement with explosives. He served as a police officer and was implicated in the plotting and execution of the attack. His petition argues that his mercy petition, pending before the president since 2012, had suffered from inordinate delay. He contends this delay has inflicted ongoing mental anguish and heightened uncertainty, conditions that undermine the fairness of maintaining him on death row indefinitely. His counsel Mukul Rohatgi drew comparisons with the Bhullar case, where commutation was granted partly due to long delays and the prisoner's deteriorating mental health. The union's response is that the seriousness of the crime, that is the assassination of a sitting chief minister, and public order implications justify the delay. Justice Mehta even noted that in certain states, prison rules prevent parole or clemency in terrorism cases. But Rohatgi pressed that regardless of how the delay came about, Rajwana should not languish under death sentence indefinitely. He asked the court to decide the plea promptly, pointing to past assurances that the mercy petition would be resolved in a fixed time frame. The court has scheduled the next hearing for October 15, 2025 and clarified that no further adjournments will be allowed at the instance of the respondent, signaling that it wants a firm decision on this deeply fraught case. The top court's frustrations with delays did not stop here, as the Supreme Court recently asked a stark question: how long can a person be kept in custody without trial? During hearings in Surendra Gadling's case, a bench of Justices J.K. Maheshwari and Vijay Bishnoi pressed the state of Maharashtra on this exact issue. Gadling is accused in the 2016 Gadchiroli arson case and has also been held in the Bhima Koregaon matter under UAPA and multiple Indian Penal Code charges. But over the years, his trial has barely advanced. The Supreme Court bench challenged this inertia directly, asking, "But why is the trial not going on? You keep a person in custody without trial for how many years?" In response, the Additional Solicitor General argued that some of the delay was due to Gadling himself. He had filed a discharge application and refused to argue unless allowed physical presence in court, which the state claimed posed serious security concerns. The bench wouldn't let that pass without scrutiny though, asking why the discharge plea could not simply be dismissed if Gadling was non-cooperative. The court then ordered the state to file a detailed affidavit explaining the reasons for delay, the pending discharge applications, how the trial is structured especially for absconding co-accused, and a timeline for completing the entire trial. The next hearing is scheduled for last week of October 2025. This confrontation is more than procedural, however. It's a fundamental test of individual liberty and the principle that justice delayed becomes justice denied. In a decision reiterating the concept of indirect discrimination, the Supreme Court granted relief to a tribal woman whose candidature was cancelled in a government post merely because she had reported a day late for the medical examination, despite having cleared the preliminary, mains, and the interview stages. The court did not just focus on her case. It used this as a chance to underline a bigger principle, the prohibition of indirect discrimination. Borrowing from its landmark gender equality ruling in Nitisha versus Union of India, the court said that even when rules look neutral and are made in good faith, if their impact disproportionately hurts marginalized communities, they fail the equality test. The judges stressed that the state, as a model employer, has a constitutional duty under Articles 14, 15, and 16 to ensure its policies don't end up excluding people who already face systematic barriers. Procedural hurdles, the court said, often hit marginalized groups the hardest. And here's the key line. Even neutral, innocent, or good faith measures will be caught if their impact on persons with a particular characteristic is harsher than on others. That's the very point of prohibiting indirect discrimination. Moving on, the Delhi High Court has dismissed a public interest litigation demanding that general elections be held by ballot paper instead of EVMs. A division bench of Chief Justice D.K. Upadhyay and Justice Tushar Rao Ghadela declined to entertain the plea by Upendranath Dalai, calling it redundant given previous judgments on the same topic. The court pointed out that the issues raised had already been addressed by the Supreme Court in Association of Democratic Reforms versus Union of India, which held that EVMs are simple, secure, user-friendly, and the introduction of VVPAT, that is, Voter Verifiable Paper Audit Trail, strengthens their accountability. The bench also noted that a similar petition had been dismissed earlier by a coordinate bench on January 21st, questioning EVM use in general polls, reinforcing that the legal position is well settled. In short, the High Court said there is no fresh ground to revisit the core issues and reaffirmed that the system of EVM plus VVPAT satisfies concerns about transparency, verifiability, and procedural fairness. Next, we look at another important ruling where the Supreme Court of India has firmly rejected a convicted rapist's plea to recall an 11-year-old victim for cross-examination. The court crucially noted that such a request would re-traumatize the survivor and undermine the justice system. The convict Arjun Sonar was sentenced to 20 years of rigorous imprisonment by the special POCSO court in Tezu under sections 376, that is of rape, and 506 of criminal intimidation of the Indian Penal Code, along with Section 12 of the POCSO Act. The Guwahati High Court upheld the conviction in July 2024. Sonar then approached the Supreme Court, claiming he was denied effective legal assistance because his counsel had not cross-examined the victim. The Supreme Court dismissed this argument, stating that the victim had given a detailed and coherent statement under Section 164 of the CRPC, which was corroborated by the medical evidence. The court noted that allowing such a plea would be a judicial insult to the sanctity of a womanhood and a betrayal of the constitutional promise made to every child in India. This decision reaffirms the court's commitment to protecting child abuse survivors from further harm and ensuring that justice is not delayed or denied through procedural tactics. Next, in a protective measure, the Bombay High Court held that when an employee is retrenched, the compensation under Section 25F of the Industrial Disputes Act is a statutory right meant to help them survive unemployment. The court reasoned that making its deposit a precondition to contest the retrenchment would unfairly bar employees, especially those without resources, from seeking justice. For context, retrenchment means termination by the employer for reasons other than misconduct, such as cost cutting, restructuring, or decline in business. In this case, two workers challenged orders by the industrial court that demanded they deposit their compensation before proceeding. The employees argued that Section 25F already prescribes that compensation should be paid when retrenchment happens, and that making the deposit a hurdle undermines that statutory safeguard. Justice Rohit Joshi, hearing the matter, agreed. He observed that even if their challenge fails, the employees should still be entitled to keep the compensation amount. Forcing a deposit would push many into withdrawing their claims due to financial hardship. The court quashed the orders that imposed this precondition. This decision reinforces that statutory protections, especially those tied to livelihood, cannot be turned into traps for workers. Next, a pan-India complaint of consumers about not being able to take outside food and beverages reached the Kerala State Consumer Disputes Redressal Commission, where a case against PVR Ernakulam was recently heard. In their note, PVR argued that food and beverages are only ancillary. The main purpose of customers is to watch movies. They said banning outside food is a standard and reasonable rule, much like in stadiums, amusement parks, and theaters, and also cited safety, hygiene, operational concerns, and the risk of alcohol or contraband. But what about drinking water? On this, the Commission made things very clear. It recorded PVR's statement as an undertaking that RO-filtered drinking water will be provided free of cost to all customers during business hours. The Commission directed strict compliance. The water must be clean and hygienic, and conspicuous notice boards must inform customers of its availability. So while outside snacks may still be a no-go, free drinking water at multiplexes is a consumer right. And finally, the Delhi High Court has imposed a 30,000 rupee cost on each of the two students who challenged alleged irregularities in the JEE Mains 2025 exam, finding they could not establish their bona fides. These students claimed their scores were tampered with. One said their percentile dropped drastically from what was initially visible, and the other alleged discrepancies in attempted questions. The court noted that while their scorecards were located on their devices, critical browsing history was missing, and without that, their version could not be accepted. Justice Vikas Mahajan pointed out that the National Testing Agency's records matched the final percentile, and that the petitioners had not convincingly explained why their browsing logs were absent. The court also relied on expert technical reports which did not support the students' claims. Importantly, the costs are meant not just to compensate but to deter unscrupulous litigants who approach courts with incomplete or weak evidence. This judgment is a reminder of the burden of proof and the need for preserved digital records. That's all for today's edition of Courts Today by LiveLaw. For full details on all the cases we covered and more updates, visit us at www.livelaw.in and follow us on Instagram and YouTube. I'm Debujit Das. Thank you for watching.